All right, welcome everyone. Let's dive right into a Supreme Court case that I think you'll find really intriguing. Today, we're looking at PDR Network, LLC v. Carlton and Harris Chiropractic, Inc. So, to kick things off, what did the Supreme Court actually do in this case?
Well, in a nutshell, they hit the pause button. They sent the case back down to the lower court, the Fourth Circuit Court of Appeals. But, and this is a key part, they didn't actually answer the central question that everyone was debating.
Oh, I see what you mean. So it's like a to be continued.
Exactly. The big question was whether a district court is bound to accept the FCC, that's the Federal Communications Commission, the agency that regulates stuff like our phones and the internet, their interpretation of the Telephone Consumer Protection Act, or a TCPA for short.
Yeah, the TCPA, that's the law that deals with things like those annoying robocalls we all get, right?
Yeah.
And all those junk faxes.
Yep, that's the one. So everyone was waiting to see if the Supreme Court would say, yes, district courts have to follow the FCC's interpretation, no questions asked, or if they'd say, no, district courts have a bit more leeway to make their own judgments.
But they kind of punted it back downfield. So why? Why send it back without answering that main question?
Because the Supreme Court identified two other really important questions that needed sorting out first. Sort of like, hold on, lower court, you missed a couple of crucial steps here. And these steps are all about how the FCC makes its rules and what kind of weight those rules carry in court.
Okay, I'm intrigued. Let's break those down. What was the first question that the Supreme Court wanted the Fourth Circuit to tackle?
It all boils down to this 2006 FCC order, the one that's at the heart of this whole dispute. The Supreme Court basically said, hey, Fourth Circuit, did you figure out what kind of rule this order is? Because it makes a big difference.
So not all FCC rules are created equal.
Right. There are legislative rules and interpretive rules. Now, legislative rules, think of those as having the full force of law. It's like the FCC is saying, this is how it is, and you got to follow it. These rules typically go through a stricter process involving public comment and all that. They have real teeth.
And then there are interpretive rules.
Yeah. Those are more like the FCC explaining how they understand existing laws and regulations. It's their take on things. Courts still consider them, but they don't have that same must-follow power as a legislative rule.
So I guess the first step for the Fourth Circuit is to figure out, hey, which kind of rule is this 2006 FCC order? And why does that matter so much in this case?
Well, if it turns out to be a legislative rule, it might be harder for PDR Network to argue against it in court. Courts are more likely to say, hey, that's a rule, you got to follow it. But if it's just an interpretive rule, PDR might have a bit more wiggle room to say, we disagree with the FCC's interpretation.
Gotcha. Okay, so that's the first question. What's the second big issue the Supreme Court flagged?
This one gets into some procedural weeds, but it's still really important. The Supreme Court asked, did PDR Network have a fair chance to challenge that 2006 FCC order before this lawsuit happened?
What do you mean by a fair chance? Like, could they have gone to court earlier?
Exactly. See, there's this law called the Hobbs Act, which sets up a specific way to challenge certain FCC orders. It basically creates this 60-day window after the order is issued where you can go to a special court, a court of appeals, and say, hey, this order's wrong, we want to fight it.
Okay, so the Supreme Court is basically saying, hey, Fourth Circuit, did you check if PDR Network had that 60-day opportunity under the Hobbs Act? Because if they did and didn't take it, well, then maybe they're out of luck now.
Right. It's like you snooze, you lose. But there's another twist. There's this other law, the Administrative Procedure Act, which might give PDR another option. It says that even if you miss that initial 60-day window, you might still be able to challenge an agency's rule or order later on during an enforcement case. So if the Fourth Circuit finds that PDR didn't have a proper chance to challenge the 2006 order under the Hobbs Act, they could still have a chance to fight it now.
So all this procedural stuff, it sounds pretty complicated. But why should our listeners care?
Because it highlights how important it is to understand the rules of the game when you're dealing with government agencies. There are often very specific procedures and timelines you need to follow. Missing a deadline or going to the wrong court could seriously limit your options.
I see your point. So to really understand why these procedural questions are front and center, let's zoom out a bit. Can you remind us about the specifics of this case? Who are the players and what's the whole fax controversy about?
Sure. So on one side, we have PDR Network. They're the company behind the Physician's Desk reference. that huge book you often see in doctor's offices with all the info about different medications.
Yeah, I remember flipping through that as a kid in the doctor's waiting room.
Exactly. Now, PDR decided to send out faxes to healthcare providers, offering a free electronic version of their reference. That's what triggered this whole legal battle.
And on the other side, we have Carlton and Harris Chiropractic, right?
Yeah.
They're the ones who got the fax and weren't too pleased about it.
Right. They said, hey, this is an unsolicited advertisement. You can't just spam us with faxes. This violates the TCPA. That's how they ended up suing PDR.
And what happens at the first stage? The district court level.
The district court actually sided with PDR. They said, look, offering a free ebook via fax, that doesn't really count as an unsolicited advertisement under the TCPA. They basically tossed out the case.
But then things changed when the case went up to the Fourth Circuit Court of Appeals, right?
Yeah, the Fourth Circuit took a different view. They reversed the district court's decision and said, no, that fax was an unsolicited ad. And this is where that 2006 FCC order comes in. They said, look, the FCC already interpreted what an unsolicited advertisement means. And that interpretation includes any offer of free stuff, even if it's something like an ebook. So the Fourth Circuit said the district court should have followed the FCC's interpretation.
So that's what brings us to the Supreme Court. Each side is making very different arguments about the Hobbs Act and how much power the FCC's interpretations should have in a case like this. Can you walk us through the main arguments that were presented?
Absolutely. PDR Network, they're basically arguing that the Hobbs Act shouldn't be a trump card for the FCC. Just because the FCC has an interpretation of the TCPA doesn't mean a district court has to automatically accept it, especially in a private lawsuit like this one. They're saying the judge should be able to look at the law themselves and make their own judgment.
And on the other side,
Carlton and Harris, along with the U.S. government, who jumped in to support their side, argued that the whole point of the Hobbs Act is to have a specific way to challenge FCC orders. That's what that 60-day window and going to the Court of Appeals is all about. They're saying if we let district courts second-guess the FCC's interpretations later on, it would undermine that whole system.
it's like two very different philosophies about how much power agencies like the FCC should have.
Right. And it gets even more interesting when you look at the concurring opinions, those separate statements written by justices who agree with the outcome of the case, but maybe for different reasons. Justice Thomas, for instance, he raises some really deep constitutional concerns.
Oh, yeah, Justice Thomas. Always thinking about the big picture. What was his take?
He's worried that forcing courts to always treat an agency's interpretation as the be-all and end-all could step on the toes of the judiciary. Like, Article 3 of the Constitution lays out the powers of the courts, and he's saying that if agencies get to have the final say on what a law means, it could infringe on the court's ability to do their job, which is to independently interpret and apply the law.
So he's saying there needs to be a balance. Agencies have their expertise, but courts also have a crucial role in making sure the law is being applied fairly and constitutionally.
Exactly. And what's interesting is that Justice Thomas thought this was a problem regardless of whether the FCC order was legislative or interpretive. He wasn't really focused on that distinction.
And then there's Justice Kavanaugh's concurring opinion. He also had some strong views on this whole debate, right?
Yeah, Justice Kavanaugh agreed with sending the case back, but he actually wanted the Supreme Court to answer the big question directly. His view was that the Hobbs Act doesn't actually stop a defendant in a case like this from arguing that the FCC got the law wrong.
He's basically saying just because the FCC has an interpretation, it doesn't mean they're always right, and people should be able to challenge that in court.
Right. He emphasizes this general principle we have in our legal system that you should usually have the right to judicial review, meaning you can go to court and have a judge review the government's actions. And he points out that if Congress really wanted to prevent people from challenging agency interpretations in court, they could have written the Hobbs Act more clearly to do that, but they didn't.
He also had some interesting things to say about a previous case the government relied on, that Yakas case from World War II.
Yeah, the government tried to use that case, which was about price controls during wartime, to argue that courts have to give a lot of deference to agencies. But Justice Kavanaugh said, hold on, the law and the context are very different here. We can't just copy and paste that old case onto this situation.
He also brought up a really important point about fairness.
Right. He pointed out that it's kind of ridiculous to expect every single person or business who might be affected by an FCC order to race to court within 60 days to challenge it, even before they've actually been accused of doing anything wrong. Think about it. For a small business owner, you might not even know about a new FCC interpretation until you get slapped with a lawsuit.
It's like being expected to know all the rules before you even know what game you're playing.
Exactly. So Justice Kavanaugh argued that this exclusive jurisdiction language in the Hobbs Act probably means that the courts of appeals have the power to directly strike down or change an agency order itself, but it doesn't mean they get to prevent district courts from interpreting the law in a specific case.
I see. So his view is that even though the Court of Appeals might have the final word on the order itself, the district court should still be able to look at the underlying law and decide if the agency's interpretation makes sense in that particular case.
Precisely. And he even pointed out that similar language in laws about the Securities and Exchange Commission, the SEC, which regulates the stock market, hasn't been interpreted to block district court review in enforcement cases. So there's a precedent for his view.
All right, so the Supreme Court has sent the case back, leaving us with a lot of unanswered questions. But this is where our 10th chair segment comes in. It's time for us to put on our judicial robes, think about everything we've discussed, and offer our own perspectives. What are your thoughts on this case?
Well, it's clear that the court intentionally avoided making a sweeping decision about agency power. By focusing on those procedural questions, whether the FCC order was the right kind of rule, and if PDR had a chance to challenge it earlier, they kind of kicked the can down the road on the bigger issue of how much deference courts should give to agencies.
It's a clever way to avoid a potentially controversial ruling, especially given the differing views within the court itself. As we saw with Justices Thomas and Kavanaugh, there's clearly a debate going on about the right balance between agency expertise and judicial review.
Right. Now, if I were to put on that 10th Justice hat, I'd probably lean towards Justice Kavanaugh's approach. This idea that you can't even argue that an agency misinterpreted the law when you're actually being accused of breaking it, that just doesn't sit right with me. And forcing everyone who might be affected by a rule to challenge it within 60 days, that's just not realistic or fair, especially for smaller players who might not have the resources to keep up with every new agency interpretation.
That makes sense. So what do you think is at stake here? What are the broader implications of this case?
I think it boils down to fundamental fairness and accountability. Agencies like the FCC have a lot of power to make rules that affect our lives, but that power shouldn't go unchecked. The courts have a crucial role in making sure those rules are being applied fairly and that people have a meaningful opportunity to challenge them if they think they're wrong. If we limit that judicial review, if we just say whatever the agency says goes, I think we risk undermining the balance of power in our government and potentially harming individuals and businesses who are trying to navigate a complex regulatory landscape.
It's a really important point, and it's something for all of us to think about, not just legal experts. What do we think the right balance is? How much power should agencies have? And how much oversight should the courts provide?
That's the key question. And I think cases like this highlight why it's so crucial for us to be engaged citizens, to understand how our government works, and to participate in the process wherever we can.
Well said. That wraps up our deep dive into PDR Network v. Carlton and Harris Chiropractic. Hopefully you now have a deeper understanding of not only the case itself, but also the broader questions it raises about the role of agencies, the courts, and the importance of finding the right balance between expertise and oversight.
Thanks for joining us. We'll be back soon with another fascinating legal deep dive.